All right, welcome back. So, as I said earlier, this is going to be the only video and readings on bias. There's a longer chapter in the book, as you'll have seen, on both procedural fairness and bias. We skipped some stuff under both because, as I said, we have to decide and we have to get to the standard of review, which is what we'll spend the rest of the course on once we're done with this. So we have cut some stuff on the procedural fairness. We'll look at bias quite briefly for the same reason. So very little to remember on bias, and that's because first, it's very closely related to procedural fairness. You'll recall under procedural fairness we looked at the various obligations that will apply. And these obligations, right, we said, depend on a number of factors, generally having to do with the nature of the administrative decision maker and the decision it makes, the nature of the relationship with the person facing the system, and the nature of the decision and its impact on the person's life, the latter being the most important one. And we said procedural fairness means you have a right to talk and be heard. That's what I said last week, right? I said first there's a claimant portion to procedural fairness, which is you have a right to make your case. If they don't let you adduce evidence, if they don't let you have witnesses, if they don't let you cross-examine witnesses, and your right to that will vary depending on the circumstances. If they don't let you do that, you don't have a right to talk, to make your case, and therefore to have an impact upon the decision. The other half of that is the decision maker. It has to make a difference when you talk. You have to talk at someone, the decision maker. They have to listen, right? You have to have an ability to potentially influence them. And that is part of procedural fairness as well. To the extent that they don't listen, you're under bias, which is chapter 7. Bias is, right, they don't listen. It's independence. We have the same problem with the syllables there as we did in the previous capsule. So, independence and impartiality, they have to be removed from the case. We'll see what that means. It essentially means that they're not supposed to not have an opinion, right? For example, believe it or not, judges have political opinions. They vote in elections and they have opinions on what is a good or bad policy. But independence is, right, they do not let these opinions influence the nature of their decision and therefore the parties who are before them. Impartiality is, right, the lack of bias, the lack of a personal stake in the case or an ability to be swayed one way or the other. Again, that's related to procedural fairness, as I said, 394, because your arguments and your various other procedural fairness obligations as to how you make your arguments, how you have your case heard, your witnesses, your cross-examinations, all of that. These obligations are not useful if they don't make a difference, if they don't have the potential to influence, right, in a positive connotation there, the decision maker, because they are, right, biased or lack independence or impartiality, and therefore it safeguards the entirety of the other procedural fairness obligations when we have that general obligation for the decision maker to be independent. So, 394 again, that connotes a subjective thing. It's a state of mind, as I said. For example, right, the judge has a political opinion, they're right-leaning. They think it's not good to spend too much money in government. Their state of mind, nonetheless, is that they put that aside. It doesn't influence their decision. So when we talk about independence and impartiality, there's a subjective aspect to it. Is that specific judge able to put their opinions aside? Is that specific judge not personally affected by the outcome of the case in an undue manner? So it connotes, again, a subjective intent. Nonetheless, and that's where it gets confusing, the test is not subjective. The test is objective. What we protect is not whether or not that decision maker indeed was biased. That would, of course, be a problem. What we protect is broader. We also protect the situations where they are in fact not biased, but it looks like they might be. Why do we do that, right? First, because we have to. It is too difficult. It's too difficult for the party stating that the decision maker was biased to look into their mind, because it's in their mind and because it's hard to prove. Therefore, we protect something broader, somewhat by necessity, because otherwise you could never prove it and that protection would be worthless. And so if the circumstances suggest that perhaps it had an impact upon their subjective state of mind or intention, then, right, that will be a violation of that obligation. Okay, for that reason, okay, so let me backtrack a little bit there. It's also because, right, in a specific situation where the person might be biased but is not, that does not safeguard the system, the justice system as a whole, right? Because the third party, not involved in the proceeding, the person who doesn't have all the details, that person might not know and might suspect that the decision maker is biased. And that's a problem in itself, even when in actuality, we know that the decision maker is not biased. So we also protect the appearance of impropriety, and that's because we protect the system as a whole, right? The system as it looks like to a third party. There is therefore no curial function, so the fact that it doesn't make a difference is not does not have a remedial function. So, for example, decision maker took a bribe. This is probably the worst possible example, right? Usually it's more nuanced, but the decision maker takes a bribe. Nonetheless, upon judicial review, you say it did not make a difference. You say, right, if they did not take a bribe, they would have made the exact same decision. Therefore, yeah, it was wrong. It was a breach of blah, 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 procedural fairness, right, independence, impartiality. Nonetheless, we don't care. It doesn't make a difference. It doesn't work that way. You don't have to show harm. And we saw that under various issues. We saw that under jurisdiction, under procedural fairness. More specifically, under procedural fairness. We said there's a breach of procedural fairness. But it doesn't make a difference. The decision would have been the same if the party had been heard. That is not a requirement. In fact, it always will be quashed if there's a breach of procedural fairness, regardless. It's not a criterion. And it's because procedural fairness, as we said, is important in itself. It's important because it's really important. It's constitutional, and therefore, even where, it doesn't make a difference, it's important. And it's important because we protect, again, the justice system as a whole. Same thing for bias. There's no remedial function if you say it did not make a difference upon the decision that was eventually made. There's exceptions for more subjective decisions, of course, discretionary. If it's discretionary or ministerial 395, there's more leeway there to consider stuff that's more subjective. It's because a decision will more likely be more policy-oriented, right? So you give discretion to a minister because you want them to use your judgment, and usually because you want them to use your judgment in a way that's likely to be not biased, because that would be prohibited, but more politically expedient to you and more politically related to your own opinion. That's fine if there's discretion, right, or a ministerial decision. So again, it's an objective test. So we protect the appearance of bias, not the actuality of bias. What does there have to be? There has to be a reasonable apprehension of bias. So what's that mean? First, apprehension means there doesn't have to be actual bias. That's what we just said. And it has to be reasonable, not just something you say and think it's so because you said it, right? It has to be reasonable. And the standard you use is a modified version of the reasonable person, which we see in a lot of areas of the law. So it's the reasonable person, but not just any reasonable person. It's first a reasonably well-informed person, because usually, right, the average person is dumb and misinformed. So they're dumb because they're misinformed, not dumb in themselves. So the reasonable person standard will be adapted that way, right? So if the average person is misinformed, we'll expect a reasonable person to be reasonably informed and also apprised of the circumstances of the case, right? So they'll have to be reasonably informed on the nature of the case, the circumstances, and the rules that apply, and that will determine whether or not, right, in their view, when applying that standard, you can find there to be, right, an appearance of impropriety that is therefore impermissible under the rules prohibiting bias. Okay, again, 398, circumstantial stuff, right? It depends, again, as it always does, especially under procedural fairness, must assess the extent of the need for impartiality, taking into account, same stuff, nature of the decision, issues to be decided, functions of the tribunal, character of the proceedings, interest of the individuals, in other words, right, impact upon the person, and whether or not the tribunal is adjudicative. As we said, that's not directly relevant. There's not a rule that says if it looks like a court, it's more procedurally fair. It's the other way around. When it's a big decision, it will have lots of procedural fairness imperatives. Therefore, it is likely to look more like a court. We said that under procedural fairness. Again, you can modify that by statute, but not too much. You can modify it somewhat by statute because that's the nature of the administrative decision-making process. It's supposed to be simpler. It's supposed to be different, and therefore can be changed, but not too much. (402), you have the discussion I gave you earlier as to, right, the fact that independence doesn't mean that the decision maker does not have their own opinion. For example, political opinions. It is that they're able to put them aside and decide the case independently. Okay. Last thing you have, which we'll reiterate, 404 or so, is that essentially it's tough to show, right? Although the standard is lower in that, you don't have to get into the mind of the specific decision maker. You just have to show an apprehension of bias. It has to be both real and perceived independence and impartiality. That lowers the standard in that. You don't have to show that it made a difference. You don't have to show that the person actually was biased, this decision maker. Nonetheless, it's still really hard to show under that standard. And that's because there's a strong presumption that you're wrong, right? If you're showing bias, it's extremely unusual for obvious reasons, especially in Canada, where we have a somewhat sophisticated justice system. On top of that, your allegation questions the entirety of the justice system, which all depends on the independence and impartiality of the decision maker, including in administrative law. It's a really serious charge. Therefore, we assume that you're wrong. We presume that there is independence unless you show otherwise, right? In other words, When you appeal a court decision, it's not for the other party to show that the decision maker was independent. It's for you to show that they were not, right? It's not a burden of the decision maker to show it. It's not a prerequisite, nor is it on appeal for the other party to show that. In administrative law, same thing. When you go to judicial review, you say decision maker was biased. It's not the other party that has to systematically show they were not biased. It's you that has to show they were. It's a presumption that they were not, and that presumption is strong because it's unusual for there to be bias in a developed country such as Canada, as it should, and because it questions, again, the stability and the independence of the entirety of our justice system. And that will be all for Chapter 7 on bias.